We want to talk to you about collaborative systems in indigent defense, which can also be called, hey, we're not alone. So really I want you to think about collaboration both within your county and on the state level as we go through this presentation. So we've talked a lot about the requirements of the Fair Defense Act this morning, and really one of the things that the law requires us to do is to be systems thinkers. The requirements follow from starting the time the person is arrested all the way through payment of that attorney. It requires that that comprehensive data can follow that person through the system. The reason is that sometimes people will say, well, our average time to magistration is 36 hours. The problem is the law doesn't address average times to magistration, it addresses individuals. And it doesn't matter if the average time is 36 hours, if somebody took 72 hours to get to a magistrate, that's a violation of the Fair Defense Act. So it's sometimes difficult to do that because our existing data management tools aren't always good communicators. You can't always just follow one person through your data systems from the time that they were arrested until the time that a voucher was paid. You may be able to do that by taking a SID number for somebody, looking them up in the jail, trying to figure out which arrest corresponds to which cause number, and then how does that compare to a voucher that you see at the end, but that's a very cumbersome process. So what we want to do is use the Bell County system. Some of you were here a couple of years ago and heard about the system that they developed to manage that data, as well as the new grant that Bob mentioned. And we want to use them as case studies to discuss systems in indigent defense, how you can start thinking like a system, and the case for collaboration. So what are systems? Well, one of the quotes from an American statistician that I found was that a system is a network of interdependent components that work together to try to accomplish the aim of the system. A system must have an aim. Without the aim, there is no system. And I think that's really important because if you think of systems that currently exist in your county, they're probably departmental systems. Your jail is a system, they have a set of aims. Your courts are a system, they have a set of aims. Your auditor's office is a system, they have aims. But the Fair Defense Act requires you to have common aims, to put those aims together across all of those systems into one unified system. So what are some of our indigent defense aims? If you had some overarching goals for your indigent defense system, what would you say that they are? So this is the participatory section, by the way. Reduce cost. Yes, reducing cost. That's a great one. Any others? Competent representation. Great one. And also, let's not forget, we want to comply with the Fair Defense Act. That's certainly one that you really want to achieve. And what is the role of data in achieving those aims? If you want competent representation, you have to have a definition of competent representation. You have to have some standards. You have to have some benchmarks. You have to know what you're doing today. That way you can get a baseline so you have something to compare it to later. If you want to reduce cost, you have to know what you're spending today. You have to know where you're spending it, and you have to be able to track that. Same thing with the Fair Defense Act. If you want to know how long it takes for individuals to get in front of a magistrate, you have to have the data to back that up. You can't just say, well, I have an average, so that's good. You have to know on the individual level. And you can ask yourself what data systems are currently available and are they adequate or sufficient to achieve our aims? Do you know what data is entered into the jail system? Most people who operate on the court side may think that they know, but sometimes when you actually go and talk to the people who are entering that data, you get a different picture of the accuracy, of the timeliness, of the level of detail. All of those factor into how you can use that data. Can your clerks create shell cases for pre-filing information? A lot of times that's difficult. Those magistration forms get kind of lost in the ether because they're not really jail, but they're not really courts yet because it all happens before filing or before indictment. So, do you have a way to keep track of that kind of information? So for Bell County and the urban counties collaboration, to give you some background, this project started in Bell County a few years ago, and they said, hey, we want to make some improvements to our data management systems that would allow us to better demonstrate our compliance with the Fair Defense Act. We are certainly all in compliance with it. We just may not be able to demonstrate that compliance. So what they did is they did a system-wide analysis and realized that they didn't have one single tool that could maintain all of that indigent defense information. So they got a grant from the Indigent Defense Commission and developed a system that's really a hub. You can manually input or electronically input information from the jail, from the courts. That way you have an incident number, you have an offense number, you have a cause number, you have a pre-filing number, you have a post-filing number, all those numbers that are generated based on one person and one interaction with the criminal justice system. They all have a place to go. So that way there is a linking pin that ties that person and that data together through all the systems. And other counties saw this and said, hey, we have a need for that as well. We have some systems, but they don't speak to each other the way that we need them to in order to demonstrate our certain compliance with the Fair Defense Act. So what we did for the collaborative project is the Indigent Defense Commission received grant requests from several counties that said, hey, we want to implement something like what Bell County did. So they said, let's take a minute to see if there's a way that we can fund all of these proposals together. And so I was part of the traveling Texas Roadshow team that visited far-flung corners of Texas. And what we saw is that, yes, there is that need for data. And we found that those data needs are surprisingly similar across large and small jurisdictions. And the reason is that you all have to abide by the same requirements that are in the Fair Defense Act. So even if you only have 100 people come to your jail in a year, or you have 100 people who come to your jail in a week, you all need to be able to track the time to magistration. You all need to be able to track when request for counsel was made, how long it took to rule on that request for counsel, when the appointment was made. You all have needs for attorney payment. So the way that the collaborative grant supports the counties is that some of those small counties, some of the smallest counties that participate in that grant probably wouldn't be able to take on this kind of development on their own. But because they can come together in a larger pool, they're able to leverage their resources. And again, the need comes from a fragmented view of the indigent defense process in criminal justice overall. We're used to operating just in our jail system, just in our court system. Sometimes, in a county you may find that the data management system for the county and district clerks are completely different, even though they were built by the same people within the same county. So there's not even a good way to tie together the county and district information, much less try to bring the auditor into that loop. So again, there's no tool to unify those data systems. So the goal for the grant project is to take the functionality that was built by Bell County. Right now there are fields for all the date and time requirements for the Fair Defense Act. You can conduct financial screenings. The system will determine indigents based on the standards for your county. You can make appointments and send those appointments to attorneys. You can generate orders appointing. Also important that order of appointment gets into the case file. The attorney can create a pay voucher. They can submit it to the judge can approve it, and it can be paid all electronically. And you can maintain the attorney wheels. So we're starting with that core functionality of data collection, data management, and in some cases, document generation, and building upon it to the additional needs that the counties said and that they would like to see. That includes electronic entry of data. Right now, there's a lot of manual entry because one of the issues that Bell County faced is that they're switching jail data systems and they are updating their court management systems. So they didn't want to build an interface that would be obsolete by the time the system was done. So we want to take on that piece in the next go-round. Also doing juvenile appointments and vouchers. Very important, and the first bite they said, hey, let's stick with adult criminal. So now we're ready to expand into juvenile. So at this point, you may be thinking, like this person, I have yet to see any problem, however complicated, which, when looked at in the right way, did not become still more complicated. And it's Paul Anderson, and we have to believe him because he lived in Texas once. So, fortunately, there are some simple steps that you can take immediately to start thinking like a system. And probably the most important is to open the lines of communication. If you don't sit down with your jail, if you don't sit down with the courts, if you don't sit down with the Indigent Defense Coordinator, the auditors, the clerks, and talk to them, then you're not going to have any chance of being a successful system. You need to understand what data people have, what data people use, and what data people need. One of the most valuable things that we did during the planning project that led to this larger collaborative grant is we held a summit in Austin. And we invited all the participant counties to come and to bring a variety of stakeholders with them. And for some of them, it was the first time that they had all truly been in a room together and talked about the system, talked about their data needs, talked about, you know, what they thought people did, and got an understanding of what people actually did. So they learned a lot from that process, I think. And you know, it's important to include your defense attorneys in that process. Even if you don't have a public defender office, bring the court-appointed attorneys in and invite them to the table because they're going to be impacted by the system as well. Then what you can do is start to develop a list of minimum data requirements to achieve your aims and tell your indigent defense story. So if you are focused on just demonstrating your compliance with the Fair Defense Act, think about, okay, what data do we need to collect in order to demonstrate that? You certainly need to know date and time of arrest. You certainly need to know date and time of magistration, date of request for counsel, date of appointment, all of those kinds of data points that feed into the Fair Defense Act. Fortunately, with this planning grant, we kind of have fleshed those out, and Joel has done it as well with his policy monitoring visits. So again, you're not alone. You can call the Indigent Defense Commission and talk about some of these issues and start to get a good idea of what your minimum data requirements might be. You also have to deploy the right tools and processes for the job. You don't want to, well, you may be able to utilize data that you didn't know that you had. Once you start talking to each other, you may find out, oh, hey, the jail enters this piece of information that, you know, we were unaware of. But you may also find that your existing tools don't do what you thought they did. One example is that in a system analysis, I discovered that in the clerk's view of a screen, the offense code was 6 digits. Well, offense codes are 8 digits. The reason that they were 6 digits is because when they built the system, they only put in 6 fields. So in order to find out what the actual offense number is, you then do a separate search for that 6-digit code so you can pull up the 8-digit code. That way you can go back and find out what it was at the jail. So, you know, that's adding a lot of clicks. In this case, it's a lot of F5s. You know, it's adding a lot of work into a process just because the tool doesn't meet the need that you have. So for with Bell County and the urban counties, like I said, we did the summit. That was very helpful. And, you know, if you're contemplating a new system, which is what we're doing right now for these counties with the Bell County system and its enhancements. One of the good things that they're doing is they're thinking about these things now, because after they've implemented, it's a lot more difficult to go back. But we're in the development phase right now, so we're having these conversations, and we are planning ahead rather than trying to look back and fix problems that are in our data. And it's very important because as Meg Wheatley, who's a writer and management consultant, said, I believe that our very survival depends upon us becoming better system thinkers. And I'm going to turn it over to Charles to talk more specifically about the collaborative grant.